of Cape Cod. The original facts of the crime were horrific. The issue is whether or not the defendant is not guilty by reason of mental disease or defect. Ultimately, that's the key that the jury needs to consider as the jury right now deliberates whether or not this defendant is guilty of the top charge. He faces a total of 30 individual counts, and the judge was very methodical in his way of going through the jury instructions, making sure the jurors understood every single element that they needed to find in order to determine guilt or not guilt on all of those charges. Orly Ahrony is a criminal defense attorney out of Santa Monica, California, and she's joining us now on the LawNewz Network to talk about this case. And a little bit later, we'll talk about the Holly Bobo case. So Orly, it's good to see you here on LawNewz.
Thank you so much for having me.
So what do you make of this case? The facts themselves are horrific enough. You've got a defendant who went through lengths of planning that went beyond any length of planning that I can remember in any trial that I've covered. Every single one of these cases is unique, and in this one, we've got a year and a half plus of intricate planning coming out of this defendant. Does it play into the prosecutor's hands, or does it play into the defense's hands a little bit better?
You know, it's tough to say, because this is what I call battling of the experts. You know, usually you see battling of the experts on the prosecution versus defense, and it makes it much easier because the prosecution's experts will agree with them. In this particular situation, you have Kelly, who is a very skilled psychiatrist, who comes on, and that was the prosecution's expert, and actually did find that both of those elements were met, meaning that in this particular situation, Loya he had a defect, he had a disease. I believe that they came out, there was a battle of what the disease was, but in this particular case, it was autism and Aspergers, which was very aggravated. And so in this particular situation, you have Kelly who says, well, you know what, although he had the defect, he wasn't able to conform to the law, and that would be on the burden of the prosecution to prove in this case.
Yeah, I mean, the state has the burden of riding over the top of this defense once it's been thrown up as a hurdle by the defendant. And part of me wonders if by throwing 4 different experts on the stand back and forth between the prosecution and the defense, if it ultimately makes it impossible for the state to prove beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect. Because at this point, the jury might look and say, well, we can believe any of the 4. And each one of them gave a different diagnosis, and therefore, there's no proof beyond a reasonable doubt that the defendant was not suffering from one of the myriad of illnesses that these experts tried to diagnose him with.
Yes, and I completely agree with you on that. I think this places the jury in a tough position, because you have 4 experts. Who do you believe? Who do you not believe? Now they're probably going to start looking at the evidence itself, the circumstantial evidence, what the detectives may have said. But in a situation like this, we are dealing with a criminal responsibility, and it is important for the jury to understand what that actually means. And when you're being torn in different situations where, one is saying, yes, there was a defect, but he could have conformed and knew what he was doing at the time, and then you have another one saying the complete opposite, it makes it extremely difficult. Usually, in my practice, I've seen where you'll have a prosecution expert come on the stand and actually support the prosecution and say, well, you know what, in this case, this person was sane, and then you might even have the defense expert say something else in support of the defense, and now it becomes just one side versus the other. In this particular situation, you have individual battles within the same side, and it does place the jury in a difficult situation because of that. So I absolutely agree with you, which is why I think they're going to really have to look at the other facts of the case. And each attorney made very compelling closing arguments here. The defense here was, their whole case was, well, these are the experts. This is what they said. The law states this. Massachusetts law states that as long as those two elements are met, then the person is considered to be deemed not criminally responsible. And I could see how the prosecution, the Commonwealth here, their entire closing argument was, well, this was methodical. How did he not know about, he planted a car, placed it on fire, placed bombs around the situation. He had this 250 pages worth of this so-called maybe love diary. And so now you have a little bit of everything. And, this will be a very interesting outcome. And I guess we'll see how it turns out. But you're right. The experts usually are supposed to be very helpful, and in this case, I think it might be a little confusing.
Yeah, I mean, talk about an interesting trial strategy, because part of the issue that the prosecutor had to deal with here, and I have never been in this situation and hope that I never am, but
I hope not either.
The prosecutor hired the first expert, and then the first expert basically came down with a diagnosis that was helpful to the defense. So rather than be accused of doctor shopping, which I guess is kind of sort of tongue-in-cheek what they did, they turned around and said, well, let's just get a second opinion. And then the second opinion was helpful, and then the third opinion was more helpful, and then the defense got a fourth opinion. So at this point, we've got not just battling experts, but this isn't just a melee or a skirmish. This is like the World War of experts in a single trial here. You got Dr. Kelly saying, oh, it's Asperger's or autism. And then this Dr. Holtzen said it was depressive disorder. And then Dr. Edersheim said it was borderline personality disorder, and it was definitely not Asperger's. And then Dr. Daignault said that it was schizoid personality, delusional disorder, depressive disorder, but not Asperger's and not autism.
Yes.
And that's just part of the chart. I was trying to chart this out as best I could. I wasn't here to listen to every single hour of the testimony, but that was most of it. And if I were even attempting to take notes on the jury, assuming that they were able to at this point in the proceeding, I probably would just be as lost as I am sitting right here listening to it.
I agree. I feel the same way. I mean, I've actually never sat on a jury before because I usually get kicked off once they know I'm an attorney. But I feel the same way. If I was listening to experts and I saw that they were just pulling me in different directions, and they're compelling, right? Because these are not just regular experts. You have Harvard grads and went to these top universities and studied, and you also don't forget these medical examinations that are fully conducted, some of them that take hours and hours. So, when you're sitting there as a jury and you're listening to one expert and you're saying to yourself, wow, this person seems very compelling. I believe them. They have the credentials. They're deemed as an expert. I believe them. And then you have number two that comes on and you feel the same way. So I think, it's very possible that what happened in this situation is that you have a jury that at one point felt that it was compelling towards the prosecution. And then the second time, they're going for the defense. And I could see how in their own minds, they're ping-ponging on what is this criminal responsibility? Because as we've seen, when the judge was reading the jury instructions, every single time he referred to whether or not this was, if this defendant is criminally responsible. And that is the main situation here that we're dealing with.
So let's talk about some of the other testimony here, because one of the survivors testified, Anna Trebnikova, was on the stand. I thought that she was poised, she was professional, she was prepared, she was observant. I'm assuming that may be a quotient of her military training through the Coast Guard, but she remembered a lot of detail. I thought that she was believable. I thought the jury would not just sympathize with her, but also believe the level of detail that she provided. And we learned through a conversation that the judge had with some of the attorneys on the record later that she almost passed out at some point in the testimony. So it was horrible for her to do that, but she did get up there with a sense of courage and strength that I think a lot of people noticed, and I can't help but believe that the jury noticed it.
Yeah, absolutely. I mean, for her to have to relive this horrific act, it's just, it would be very difficult for anyone to do. And she really did her best and held her composure. And I feel like it was important for the jury to see. I mean, who better than, the person who was actually there witnessing the shots and everything that was going on. And you know what? For her to recall much detail is just truly amazing, because when we think about certain crimes that are committed, and you're thinking about, okay, can you identify the suspect? What were they wearing? Is there any identifying marks? A lot of people can't. And that's where you get with, situations of wrongful convictions or whatnot. But in this situation, yes, she did do an amazing job. She was able to recall the events, and that's exactly what I'm saying here, is that because we have the battle of the experts, now they're going to be actually probably focusing on the direct evidence, which would be her testimony.
Well, I mean, is that ultimately proper? I guess this is sort of a legal, moral question all rolled into one, but if the defendant is admitting that he did it, which he has to do to proffer this defense,
right?
I mean, should the jury really be sitting there and talking about, well, I really believed the victim on the stand? I mean, but for some of the aggressors for the charges, they have to find that this was something that was committed either with deliberate premeditation, which doesn't seem like it's that hard to find, considering the amount of planning, the documents, the videos, the deer camera, all of these other things, the car being set on fire, the fake bombs, all of this other stuff. I mean, if that's not deliberate premeditation, that is like, this is exactly what it is. There's no wiggle room in that. But extreme atrocity or cruelty, well, that might be important to consider her testimony. But again, I mean, they can consider it all they want, but they've got to determine as part of this. I mean, the elephant in the room is whether or not he was suffering from a mental disease or defect. It's all going to keep going back to this war of experts.
Yes, absolutely. And so, I feel like the jury's in a situation, whenever you're a jury, you are faced with something morally at this point, right? Somebody died, and it was in a horrific, tragic way, 15 rounds of bullets. I mean, and the wife needed to see that. I mean, and, her last words to her was, I love you. I love you too. I mean, there's no other way to explain this. I do think that Anna's testimony was helpful because, in a sense, at least for the prosecution, because it might support the fact of the premeditation in this situation. But again, you're right, because we're dealing with criminal responsibility and this defect. So even if we talk about premeditation here, is whether or not this defect that he was suffering from, one of the 4 concoctions of these doctors, did that have an effect on him to the point where he couldn't conform to the law and then just stop before he shot and say, hey, you know what, I know I'm doing something wrong, I shouldn't be doing this, before the first bullet was shot.
What do you make of this manifesto, as I've been calling it here, this document that's 250 pages long, titled Loya Wars, and there are some other just very strange titles for some of these documents. What do you make of what we have heard on the record from those forums?
It's really hard. It's confusing at times. And I could see how this piece of evidence might actually be helpful to the defense, in the sense of showing his Aspergers or his autism because of what he's writing, because of what he's saying. Some of the things that he mentioned in regards to being very specific about moments that he may have shared with Lisa and what happened. I mean, when you think about that, you're like, well, you know what? I don't know, would a reasonable person write like that? Would they include those types of facts? Would they share a story in that sense? So I think that it's helpful in the sense to kind of know what he was thinking. And I'm sure that this was probably what the psychiatrists may have looked at as well, when making their conclusions in this situation.
Yeah, let's go to another clip of the prosecutor's closing argument here, because I think the prosecutor really tried to summarize this as sort of an overall theme that, hey, look, you can find that this guy has something mentally wrong, but that he was still criminally responsible because the DSM for mental illnesses is not the same standard for criminal culpability. I think the prosecutor was very clear about clearing that up, and it's critical that the prosecutor did clear it up. So let's listen to a little bit more of that, and we'll be back with more analysis in a bit.
And what's your most competent tool to do this? It's your common sense. You don't leave your common sense to the door when you come in to sit as a juror. Now, the defendant is certainly presumed to be innocent, but only until he's proved guilty beyond a reasonable doubt, which I suggest, again, we've done in this case. The Commonwealth has the burden of proving to you beyond a reasonable doubt that Adrian Loya murdered Lisa Trebnikova, shot Anna Trebnikova and Jerry McDonald, and all the other crimes that he's charged. And there are a number of other crimes that he's charged. But I have a limited amount of time, and I'm going to focus mostly on what I would suggest to you are the most serious crimes in this case. And you wonder why there's so many exhibits in this case of the defendant saying, I did it. We still, the Commonwealth, have the burden of proving to you, beyond a reasonable doubt, that he committed these crimes. And then we have the additional burden of proving to you that he was criminally responsible. That's why there's so many exhibits. We have to prove that it happened, that he's responsible, and then we have to prove to you that he's criminally responsible. And I know it got tedious at times, listening to the evidence technicians talk about, I found a shell here, I found a shell there. Yes, that's where I found that. But we have that burden. And we accept that burden, and I suggest at the end of the day, we've met that burden. The Commonwealth is proceeding here under two theories of the charge of murder. The judge is going to instruct you about that, but I feel, give a little background about what it is we need to prove. The two theories are deliberate premeditated murder and murder by extreme atrocity or cruelty. All right? The Commonwealth must prove to you all of these theories seem beyond a reasonable doubt in order for you to convict Adrian Loya. But I suggest you prove both of those, and you'll be able to, in your burden slip, find the defendant guilty of one, or two, or none. But I suggest we've proven both theories of murder in this case, deliberate premeditation and extreme atrocity and cruelty. What then is deliberate premeditated murder? I suggest it means there was a plan, some contemplation that was involved. And I think there's an overabundance of evidence about the evidence concerning a plan. And what about extreme atrocity and cruelty? I suggest it has to do with the way in which the crime was committed. That the means that were used to accomplish the death were extremely atrocious and or cruel. That's not control, it's an or, not an and. 11 gunshot wounds in Lisa Trebnikova. Now, the Commonwealth must prove to you for deliberate premeditated murder that Adrian Loya caused the death of Lisa Trebnikova and intended to kill Lisa Trebnikova and committed the killing with deliberate premeditation. Caused the death of Lisa Trebnikova. I would suggest to you that it is uncontroverted in this case. That Lisa Trebnikova was killed as a result of 11 gunshot wounds inflicted by Adrian Loya. Intended to kill Lisa Trebnikova. I would suggest to you infer an intent to kill when someone uses a dangerous weapon upon another person. And Mr. Loya used a pistol. He intended to kill Lisa Trebnikova. What other intent could Adrian Loya possibly have as he shot 15 times into that mattress? Other than those shots hitting and causing the death of Lisa Trebnikova. This was not an accident. This was not a justifiable killing, such as in wartime or something like self-defense. This was 15 attempts to end the life of Lisa Chubby-Covey. And incidentally, not even caring about the life of Anna Trump. Deliberate premeditation. Did the defendant decide to kill Lisa Chubby-Covey after some period of reflection? I'm going to suggest that Commonwealth has proved overwhelmingly that Adrian Loya thought and reflected upon killing Lisa Chubby-Covey. He planned this killing out months in advance, I would suggest to you. It may not be a brilliant plan. It doesn't have to be even a compliment, but it was a plan that he implied and used in this case. What evidence do we have of Adrian Loya's plan to kill in this case? Well, we have Exhibit 67, which is his first interview with the police. In that, Loya says, and instead of taking myself out in my bedroom or something, I wanted to show her what she created. And then basically take, and her. Dover says, when you say take her out, what did you mean? Mr. Loya, murder her. Dover says, you wanted to murder her? And Loya says, yes, sir. Later on, what was it that you did? Loya says, I murdered a woman. Dover says, and what was that woman's name? Loya says, Lisa Berlina Trubnikova. Later on, Dover says, and so I guess that what you're saying to me is that it was your intent was to first go there and murder the young lady? And he says, correct. Later, Loya says, I didn't want there to be any question saying it was a senseless murder or a terrorist act or something like that. It was a very personal act of revenge. And that's your motive here, isn't it? Revenge. My mind was just to get in contact with her and remove her. Trooper Dobbin asks, when you say remove her, Loya says, it's murder. Loya says, well, from once October, and I saw that here's a place. Here's what it looks like. It all just easily fell into place of what I needed to do was make an obstacle because I'm going to be stopped immediately and give me time. And then cause a threat to where after I murder Lisa, cause a threat to where the police officers would shoot me. Loya later says in the same interview, and this is where, in his answer to this part, and I know I'll have to talk to more people after this, after I guess, convicted or whatever, you know why I did this. It wasn't just a random killing, or, me just saying, oh, here are some girls, I'm going to shoot them.
So right there, we were listening to the prosecutor try to say why there were so many experts here and tried to get the jury to say, hey, look, it was part of our attempt to prove things beyond a reasonable doubt, but beyond a reasonable doubt, I know doesn't necessarily mean unanimous,
Right.
but it really invites the jury to get into the weeds on what these particular witnesses said. And the judge, who's ruled this courtroom with an iron fist, said he's not providing any transcript readbacks for this jury, period. So they've got to rely on memory, and I would not want to be on that jury. Because here's my take. I think that the one doctor, the first one who was on the stand, wound up undermining his own credibility based on his own assessments more than once. For instance, when confronted with the defendant's writings about the best day of his life was when he caught the scent of the victim up in Alaska, and just, I mean, it reads like some guy who's just, love at first sight, obsessed with somebody. And yet the first doctor is like, oh no, I don't think that's what it is at all. And I'm just like, seriously? So part of me wonders if the jury can easily dismiss them, but that's if they're really in the weeds on the testimony, the way I listen to it and then think about it and then rewind it and play it again and get the benefit
Right.
of hearing it 2 or 3 times. So, I don't know. I mean, does the jury get that far in the weeds on a case where maybe they need to be without the benefit of a transcript readback?
Right. Well, that's tough. It's so tough when you don't have that opportunity. In my cases where I've seen transcript readbacks are very helpful because they're like, wait, what did this person say? What did this other person say? And that's really the turning point for them. You would hope that they took notes And, you're talking about different jurors. Maybe some are more studious than others. So as they collaborate, hopefully, somebody took better notes on this psychiatrist versus the next. But you're absolutely right. In a situation like this, where you have to rely on your memory, which, is quite tough in a situation like this, because I think this case gets very technical, and it's been pretty lengthy. I definitely feel bad for the jurors in this situation.
Yeah, there's one more really bizarre thing that happened, and we don't have the audio of it, but we have the clip of it. Our crew in court said it was audible, although the microphones didn't pick it up, that the defendant, towards the end of the jury instructions, when the judge was about to call the attorneys up for a bench conference or something, said guilty. And it looks like from the video that he said it, looked at another juror, said it again, then looked at another juror and said it again. So let's watch the clip, and I'm just curious about your reaction to this. I've watched that a couple of different times, Orly, and I've been trying to lip read, and it's a little bit hard because we're looking at the the defendant from the side, but I'm reading the lips, and that's exactly what it looks like he said. Was guilty, turned to another juror, said guilty, turned to another juror, said guilty. What do you make of it?
I'm shocked. I'm thinking to myself, what is he doing? And if his attorney saw that, what would he be saying at this point? I mean, who knows what he's saying? Is he talking to himself? Is he having a side conversation? Is he just maybe trying to make himself look like he's insane? I mean, I know he's been deemed competent for this hearing, and it took about a couple of years to get him there. But when I saw that, I was like, wow, I'm shocked. And I have the same reaction as you. There's no other way to read that.
I have to assume the judge didn't hear it, because if I were the judge, I'd look at him and say, are you changing your plea? I mean, seriously?
I would feel the same way. I mean, if I was the judge or the attorney, I'd be like, my goodness, we've worked so hard to get to this point. What are you doing? You know what I mean? And I don't know. I mean, we saw it. Who knows who else saw it? I mean, were the jury able to lip read? Did he say it loud enough for them to see? Was he saying something else? But I'll be honest with you. I think I heard what you heard in this situation.
Yeah, and like I said, the microphone didn't really pick it up, but who alerted us to it was our crew member in the courtroom who's there recording things. So it must have been loud enough to have been picked up ambiently, because our guy's in the back of the courtroom.
Oh yeah.
And I'm assuming maybe that because the movement was such that people were walking up toward the bench.
Right.
And part of me wonders if, maybe the judge, maybe the attorneys didn't catch it, but if the jurors were looking at the defendant, then I have to believe that, he was making eye contact with them. So I would have to believe that somebody on the jury picked it up.
Right. And the thing is that jurors, you're told you can only look at the testimony at trial, the evidence at trial. Don't take anything outside from it. The judge was very stern about their cell phones. He's like, you can live without your cell phones, they're not coming in. So, their job is to, hey, look at the evidence, what's been presented. But how are you going to stop a juror from listening to that and thinking to themselves, what did he mean by that? It's just natural. We're all people. This is something that happened. And if I was a juror and I saw the defendant was saying guilty, I would be thinking to myself, does he want us to find him guilty? What's going on here?
After calling that many experts and having this amount of expense at trial, I don't know. Or is he trying to get them to believe that he's suffering from a mental defect? Right.
I mean, it could be. And, what would be, I would be very curious to know is what his attorney would think, what his defense attorney would think of this, most importantly.
Well, it's one of those questions that oftentimes we do hear from the litigators in these cases after they're over, because as you well know, one of the hallmarks of the legal profession is at least supposed to be civility in the midst of battle. So attorneys can argue all day in court, but then be professionalism is the buzzword. When they're not. So oftentimes, both prosecutors and the defense attorneys will come on LawNewz to talk about the case afterwards. If the defense would so accept the invitation, one of the questions I will have is, did you hear your client say this? So,
Absolutely.
you know, I'm curious. But I want to take some time to talk with you about the Holly Bobo case out of Tennessee, because we're going to be covering that starting on Monday, and talk about a case with a drastic number of what-ifs, who done it, what were there 6 people arrested in the course of this thing. They're presumably covering for one another. They may or may not be telling the truth about one another. There's allegedly a video of one of the defendants raping this poor victim, but nobody seems to know where the video is, or if it still exists, or you know exactly who was involved with it. I mean, we've had testimony on the record that people have seen it, but you know, that's one bizarre piece of this. They don't have the video from what we understand, and then they've got this gun that was found, I believe, in a stream. It's all rusted.
Right.
Okay, and they found it this year, and it's been how many years since the girl went missing, and then, you know, her remains were found several years after that. So it's like, just talk about a bizarre set of circumstances here. So much of what we know is just little tidbits. It doesn't paint a clear picture of a crime.
Right. I mean, and then you had one of the suspects who committed suicide. And so, you know, it's interesting. One of the other suspects, I believe it was Jason Autry, if I'm not butchering his name, he's going to have some sort of immunity to testify at trial. And Zach's brother, if he goes on the stand, will plead the fifth. So you have a guy who has a motive, who is given immunity in exchange for his testimony, and he, you know, that might make him say certain things, not say certain things. You have 2 brothers here, so obviously they want to protect each other. You know, one wants to cover the other one, and then you have this gun out of nowhere that was found on Memorial Day, and now they're saying, well, we got to try to do some testing. But you're right, there's too much rusting on the gun, and so I don't know if they're going to be able to do that.
They can't. No, they can't do ballistics on it. They've got no DNA. They've got no blood on it. Well, it was rusted, and it was. There's one report that said it was found underground, and there was another that said it was found in a stream. And I don't know if both are accurate or one or the other is accurate. You know, normally metal takes a lot longer to rust when it's underwater than it does if it's under some leaves or brush or something like that in Tennessee. But you know, this Holly Bobo disappeared in 2011. They found her remains nearly 2.5 years later in 2014, and then this gun turns up in 2017. And I don't know how far they're going to really be able to go to link it to the defendant. You know, the defendant is Zach Adams, and then you've got these other 5 people that were arrested as parts of it. And you're correct. One is supposed to be pleading the fifth if he gets called. You've got other ones getting immunity of various degrees to testify, and you've heard these cases 1,002 times. Whenever somebody gets immunity, then there are immediate questions as to whether or not that person is even being truthful.
Right, and that's the thing, because if you're being truthful, why do you need immunity if you have nothing to lie about?
Well, because they were involved. That's part of the reason why. Because they're ultimately co-defendants in their own right.
But we're talking about a situation that everybody is pointing the finger at somebody else, and nobody really wants to tell the truth. So that's why it even makes this whole immunity situation, you know, more questionable. Because we don't really have hard evidence as of yet. That video obviously would have been helpful to know, what exactly happened, who was involved, and in regards to the gun, I mean, we'll find out at trial the discrepancies as where it was found, because obviously the prosecution, if they intend to use it, will have to lay that foundation. So we'll find out hopefully more about that next week.
Nick, one of the local reporters picked up on this, and bravo to that reporter, but there was a little discussion in court somebody did zero in on, because I think it was a little bit of a discussion, and it's a much bigger issue, of an alternative suspect. There's this other guy who was a known rapist who had a history of sex crimes in 77, 87, 96, and another one in 2008, 10 months after Holly Bobo disappeared. He lived 10 miles away from Holly Bobo when she disappeared, and then 10 months later winds up getting arrested for a sex offense a couple of counties away. And apparently, I feel bad for this defense attorney, because every time I think she tries to make a move to actually defend her client, she gets stonewalled by either investigators or the judge or something. And I think that she talked about this in open court because she's trying to get more information, but I don't think that it went anywhere. But it's another one of these things like, okay, well, what's he got to say about it? Was he fully investigated? Was he interviewed? If he was interviewed, where's the record of it? And those are things that I'm waiting to see if they come out as well.
Absolutely. And that becomes, if, for example, the prosecution or they conducted an investigation and they interviewed him, and they may have given, and from his testimony he had given some leads that he may have been involved in this, and that information wasn't shared with the defense, that would be a major problem, because now we're talking about possible Brady, and so discovery issues. So it really depends as to how much information did the prosecution have on this. Do they reasonably believe that he was associated with this victim or not? And that would also be very interesting to see how it would unfold. And of course, that would be the best defense if this is the fact that Zach Adams is innocent, and this other sexual rapist was in fact the one who committed this crime.
Yeah, I'm really curious to see exactly how that issue was discussed, because I see a possible Brady issue. The defense attorney, I'm looking back at my notes here, accused prosecutors of failing to provide a recorded interview with this guy. Well, gee, it's been a while since I've read Brady, but if I'm remembering it properly, it hits the nail square enough on the head to satisfy me. But let's, I don't like to get into the habit of bashing judges, because they have to make tough calls that a lot of people don't frequently have to consider, and a lot of times, as the saying goes, they go home feeling lousy about their job at the end of the day. But I gotta wonder, at one point this judge in the Holly Bobo case made a comment that all of these defendants should be pleading out and not fighting the charges. Well, how does that not count as judicial bias under the rules for judicial conduct?
You know what? It does. In my book, as a criminal defense attorney, I think it certainly does. He's already sharing his predisposition of what he feels the defendant should take, meaning that if he thinks that they should take a plea, that means he thinks they're guilty. And in my book, that would be biased, and I would not want to be in front of a judge like that. And I understand that they tried to recuse him, but that didn't really go anywhere. So I believe that he's going to be the presiding judge over this matter.
Yeah, that's my understanding. I have to worry about Rule 2.3 in the Tennessee Code of Judicial Conduct, the judicial canons. I forget the exact name, but I did look them up. You got Rule 2.3 issues about being a neutral arbiter, and that's a constitutional issue. The Supreme Court has ruled that the part of the guarantee of a fair trial is having a neutral judge. They decided that issue, I think it was like 75 years ago. So yeah. Part of me wonders, okay, well, now you've got an issue on appeal about that, and then you got this little side thing where the judge himself got arrested for having a weapon within the past week or two, in the secure zone in an airport. So it's like,
Yes.
what's up with that? You know, how does it influence this case? I haven't seen any evidence that it's affected it, but this just blew up and became public late in the day yesterday.
Right. Well, he might not be presiding anymore, depending on what he might be facing in this situation. I mean, who knows? Was it legal? Was it illegal? You know, what's actually going to happen with him? So it is very interesting to see how that situation would pan out.
Yeah, I'm really curious to see how this is going to go. We do have a sense of who we might be seeing as witnesses here. Apparently, there were about 100 subpoenas that went out. We know a couple of names. We've got an expert from a university in Tennessee to talk about the remains as they were found. That seems pretty commonplace. We see that in a lot of trials. We've got somebody else from a laboratory in Nebraska who's going to talk about the gun, and I'm really curious how they're going to deal with this because, you know, it's a 32 caliber. It can't be tested because it was heavily rusted, so we don't know if any bullets can be we can't look at the striations on the bullets is what I'm trying to say. We don't have any DNA. There's no blood on it, and apparently the defense attorney said this thing can't be in any way linked to the defendant. So it's like,
Yeah.
what's the relevance? I mean, how do they even know that this is the gun that was involved? Was it found in the same exact area? I don't know the answer to that, but part of me is wondering, like, what's going on with this investigation?
I feel the same way. I mean, was it the dogs that was helping with the scent? Maybe they knew the scent of the defendant. They're like, okay, let's go find the gun. You know, it's a mystery. I agree with you. Where did this gun all of a sudden come from, and why are we linking it to this defendant? I think the problem here is that the prosecution, obviously we all know this, they have a high burden to meet beyond a reasonable doubt. They can't come in having, you know, it's really hard to prove your burden when you don't really have a weapon and you don't really have DNA evidence. And so it would obviously be helpful to them to say, okay, let's just, if we're able to get the weapon, then that's the smoking gun, as we say. And so I think that's why they would be pushing for it in this situation, especially because we just talked about the fact that one suspect ended up committing suicide. The other is the brother of Zach, you know, who's going to plead the fifth. And then you have another one who was allegedly there and is going to be granted immunity. So if the gun can't be tested, what's end up going to happen in this situation is you're going to have just the testimony, and it's going to shake down to who is the jury going to believe. Are they going to believe Jason's testimony because he was there and now he's granted immunity, and he's going to impute that liability onto Zach?
Yeah, I have a lot of questions about this. And look, I mean, we're talking about a couple of different cases here that have a few parallels but not many similarities, because I always look at these cases and say, look, and I've done this for years. The prosecution has the burden, okay? So as a reporter, I'm always looking at whether or not I think the prosecution has met the burden, or whether the prosecutor is trying to pull wool over my eyes or obscure something. And so never mind the law, look at how vicious the crime was. Well, they don't get to do that. And if they do that, I call them on it. So we've got the Bobo case where maybe it's just that we don't know all of what they have. Maybe they are playing this so tight to the vest that they don't want it all out there, and maybe that's why we don't know a lot about it. And if that's the case, good for them. I'll be anxious to see what they can prove at trial. Keep in mind that case is being tried in a rural county with, I think the population of the whole county is like 20, 30, 40,000 people, so it's small. I had the number on the tip of my tongue a couple of weeks ago. I've forgotten it off the top of my head. But we're talking about a small community with the murder of a young woman who seems to have been well-known and well-liked, who is related to a country music singer in the area. Okay, so people know who this woman is, and it gets national attention. So at a minimum, they know, oh yeah, it's the murder case that everybody's talking about, of course, including us. So I'm wondering what the prosecution's actually got and whether the prosecution's going to meet a burden. But then I'm comparing and contrasting this with the Loya case, where the jury is deliberating right now.
Right.
And there, the issue is that, yeah, the prosecution has the burden, but they've thrown enough into evidence to at least presumably ride over the burden, although I don't think it's a slam dunk. It's a layup,
Right.
but it's not a slam dunk.
Right. And in the Loya case, we have, Loya saying, I did it. The question's not
Yeah,
who
the
did
end.
it. Let's point fingers at everybody here. So because of that, I guess it makes it easier for the prosecution because you're only dealing with one defendant, and you have the guy who puts his hands up in the air and says, I did it, and gave, I believe, more than a few hours of interrogation and was very forthcoming. So it is very, it will be, in this situation with the hobo case, it will be a situation where it will come down to maybe a difficult decision for the jury once again to make, depending on what the evidence shows. But the most important part is hopefully the prosecution will share whatever it did find with the defense to avoid any kind of Brady violations, because that would be, the most important.
Yeah, exactly. I'm really curious to see how the jury's going to come down on the Loya case. They're deliberating. They've had the case for, about an hour now, I think. So, Orly Ahrony, I know that you have to run. Thanks for joining us for about an hour here on Law News. Good to hear your insights.
Thank you so much.
We are going to continue listening to some of the prosecutors' open or closing statements, rather, in that case. The jury's had the case for a while, and we'll be back with our next guest, Alan Turkheimer, who's a jury consultant. He's going to try to help us walk through what's going on in the minds of the jury right now in the Loya case, especially considering they've got to try to weed through 4 contrasting experts who ultimately all said different things. So we'll be back in just a second with more analysis.
Later on, Lawyer, but it was a life I wanted to take. Donovan, you've been thinking about this a long time.